Hi, everybody. Welcome to the MSBA presentation on commercial foreclosures in Maryland. I am Rich Costella, and I'm a partner at Tydings Rosenberg in Baltimore City. And a big part of my practice is commercial foreclosures, along with bankruptcy, creditors' rights, and commercial litigation as well. So, Mike, do you want to go ahead and just do a quick introduction? And you're muted.
Hello, everyone. This is Michael Bolesta. I'm a partner at Gebhardt Smith. I handle commercial loan transactions and workouts, bankruptcies. We represent lenders almost exclusively. And I've been doing this for about 13 years. So I started with commercial foreclosures right when the Great Recession hit. So I got a lot of experience doing that. So I'm looking forward to doing this. And I think Rich is going to kick us off. But I also see that Sean is on the webinar now. So I don't know if he wanted to make any opening remarks.
Yep, sorry about that, a technical glitch. Thank you again for joining us for another installment of the Commercial Real Estate Discussion Group Luncheon. Unfortunately, because of the situation with COVID, we can't see each other in person. My name is Sean Goldfaden. I'm Vice President and Commercial Underwriting Counsel for Land Services. We are a large commercial national title agent. Just some housekeeping issues quickly. On October 13th, we're planning to have our next seminar. That is going to be a discussion on commercial property insurance. We're going to be discussing pitfalls and practice tips. We hope to have, every month another installment of the commercial discussion group. I am looking for topics of interest. If anyone has any, please reach out to me directly with any recommendations that you'd like to see. I don't know if it was addressed earlier, but you can, for this webinar, you can type in your questions on the YouTube chat or email them directly to Angela at msba.org, which is on the site right now. We are honored and privileged to have two very special and prolifically knowledgeable guests, Richard Costella, Tydings, and Michael Bolesta from Gebhardt Smith. I think Mike already discussed his background. Rich is a partner in the Bankruptcy Creditors' Rights Group at Tydings. His practice focuses primarily on bankruptcy and commercial litigation matters. He has a wealth of knowledge related to commercial foreclosures, workouts, title-related issues, and debtor in possession financing. Is one of the foremost experts in bankruptcy matters. We are very excited to have both these gentlemen with us, and I will let them take over at this point.
Thanks, Sean. Rich Costella here again, and Sean's going through my biography there. I'm looking around. It sounded like he was talking about somebody else, but I appreciate those kind words. As the materials state, this is a webinar on commercial foreclosures. We want to kind of hit on some hot points on commercial foreclosures generally. But we also want to kind of be current with current events and talk about some of the issues that have come up with COVID, some of the legislation, federal and state legislation that's come out that may affect commercial foreclosures as well. And I think at the top of that list is the federal foreclosure moratorium, which actually expired in August, and then the first week of September was extended through the end of the year. And it's the moratorium is actually part of the CARES Act, which encompassed a lot of stuff. Believe it or not, it actually has a provision that amends the bankruptcy code, as well as setting the moratorium and on evictions and foreclosures. And the biggest thing to know is that the moratorium on foreclosures applies to federally backed mortgage loans, but it only applies to residential real property, which may seem like, why are we talking about this in a commercial foreclosure webinar? Well, the definition in Maryland of residential property is 1 to 4 family residential real properties. And that could very easily, and it does, encompass small apartment complexes. You could have I know in Frederick and Hagerstown, there's a lot of these really beautiful old houses, and a lot of them have been broken up into apartments. And they may be, 2 or 3 or 4 families living there. So the moratorium, the federal moratorium on foreclosures would apply to those. So even though we're talking about commercial in an apartment building with 1 to 4 families living in it, it's not technically a commercial foreclosure, but there's a lot of people that that are in business and own those things and run it as a business. So just to be aware of that even though it's could be technically residential real property, the moratorium will apply for to properties that are just not single family homes. So what is the moratorium? The moratorium on foreclosures basically affects, to coin a phrase, federally backed mortgage loans. And you can see on the first page there what that encompasses. It's basically any FHA-backed loan, any loan from the Housing Community Development people, Department of Veteran Affairs, even the Department of Agriculture, and of course your favorite government housing people, Fannie Mae and Freddie Mac as well. And these can be loans that are not only direct from those organizations, but also if they're insured or backed by those organizations. An interesting thing and to keep in mind is that, and I've had this actually come up recently, if you have a vacant or abandoned property, it's actually excluded from the moratorium. And the list is pretty comprehensive, but interestingly enough, it does not cover all federal agencies. I actually do a lot of farm credit work, and the Farm Credit Administration, who regulates some of those lenders, has not put a moratorium on those types of mortgages or deeds of trust or loans. So keep that in mind. It's all that information is available online. So it's if there's a question, just go and check, and whatever the organization is, just go and check on their website, because there's a load of COVID information on there. So one of the things that Maryland has done as well is basically just honored the moratoriums, and under a recent administrative order, there's a requirement when you're doing the foreclosure, and it's probably only has to do with the 1 to 4 family residential real properties definition that I had discussed earlier. But there is a declaration that is required, and you'll see on under B2, there's actually a list of what's required. It's a little bit tricky because, as I said, I represent some farm credit agencies, and although they are a government-sponsored entity, they do not have a moratorium. So when you're doing the declaration, it actually requires you to identify whether or not the loan at issue is from a government-sponsored entity. It almost kind of seems like that's saying, well, if it is, even if they don't have a moratorium, then you're not allowed to foreclose. Well, we've done a few where there's been abandoned properties, there's just been no moratorium on a specific lender, and have filed those with the courts, basically saying, yes, we're a government-sponsored entity, but there's no moratorium on our lenders, and kind of go through the history of the Farm Credit Agency and how it works and that type of stuff. And the courts seem to be accepting that. So that's a good thing, that if as long as you kind of explain why the moratorium doesn't apply, even if you're a government-sponsored entity, it seems like the courts are okay with that. Mike, I know you have a problem with some of the moratorium too, in getting things filed. You want to talk about that?
Yeah, I just wanted to mention, and I'm sure some people on this call have experienced this, but the various circuit courts in the state have taken upon themselves to attempt to stay all foreclosures, commercial and residential, because of these moratoriums and these administrative orders. And I've had that happen several times. I had a case that was pending at the beginning of the pandemic, and I was just trying to get an audit ratified. I have one now that I'm trying to proceed to the foreclosure, and I was filing a bond, and they indicated that I needed to comply with this declaration requirement. really need to stay on top of this, monitor the docket, make sure that your pleadings, especially if they're e-filed, are being processed, because they won't process it if they believe that it's subject to this declaration requirement. You'll have to call the clerk up, plead your case, in some cases, move heaven and earth to get them to realize that this does not apply to commercial foreclosures. I had to go through the chief judge down in Anne Arundel County to make them act upon our audit. And our client we were sitting on millions of dollars, and they were getting very impatient, and it took months. It finally was resolved, but I just want to make everyone aware that this is a potential issue. And I think it's been ongoing ever since they made the distinction between commercial and residential properties way back when. There are still clerks that make that mistake and seem to want to apply all the residential restrictions on commercial foreclosures.
Yeah, and I really appreciate what the clerk's office does, but when they start playing lawyer, Mike, you want to talk a little bit about section 2 on page 3 about the just the notice requirements before we get into the actual foreclosure stuff?
So before we begin the foreclosure process, we need to make sure that we have our ducks in a row. And I tend to think that this is one of the most important parts of this whole process, because if you make a mistake here, it can get rather expensive. So first thing you need to do is obviously take a look at your loan documents, take a look at the default provisions, make sure you actually have a valid default. Your client is obviously going to tell you that. Most cases, it's going to be payment default. Need to make sure that your deed of trust has a power of sale or a statute to decree provision. Make sure your deed of trust can authorize the substitution of trustees, which almost all of them do. Check and see if the deed of trust has any special notice provisions. And you want to make sure that you accelerate and demand payment before you start the foreclosure process. There's been instances where judges have asked that question, not necessarily in the foreclosure context, but in other collection matters. So I think that's just an important point. If the client has already done that, we still do it just as a matter of course, and accelerate and demand under our letterhead. The next point regarding title work. In most cases, with larger commercial loans, you're going to have an existing lender's policy. You want to get that as soon as possible. You want to get a updated lien search. We use Harbor City. There's other entities out there that do the same work. But I like to get that lien search as soon as possible. I like to compare it with our existing lender policy. And if we know that we're going to move forward with the foreclosure, then we always get a commitment, typically on the same title company provider. So you're saving a little bit of money on the reissue rate. And you want to make sure that you compare those different searches to see if there's any missing liens. It's happened before, so I always double up on my Harbor City search and the commitment as well. So you need to have your title searches updated to within 30 days of the foreclosure sale. So that's an ongoing process. And if you have some type of tickler system or calendar, once you schedule your sale date, you're going to want to calendar back 30 days or probably 45 days to make sure you have that search in within the 30 days before the sale, so you know that you have all junior liens. There's a note here, COVID has slowed title work. So this is something that you want to get done as soon as you get the file in. You definitely want to have a good idea of what liens are out there. If there's some liens that were refinanced as part of your initial loan and they weren't released, that's something that takes a long time. So I always ask my title company that I obtain my commitment from to start on that right away, because those third-party items that are out of your hands can take quite a long time. And if you're under the gun and your client wants to foreclose as soon as possible, you want to get your title work ahead of time. The next issue, the environmental reports. And this is really part and parcel with does the client want to own this property if they end up foreclosing? So they need to have a good understanding of what environmental issues affect this property. You may need to have your client order an update. Some of the larger institutional banks have rules where they'll need certain appraisals and environmental reports within a year. They have to be updated every year. So you want to make sure that the client is ordering those reports on a timely basis. And again, because of COVID, because of if you're in a foreclosure position, you're probably not going to have a lot of cooperation from your debtor. That may cause issues as well. But that's something that you want to get done as soon as you can. And you need to review that. There are certainly certain types of properties that your client is not going to want to own. Gas stations, laundromats. I had a case, and I think Rich has a few examples here as well. We had a case where we were foreclosing on property that was, it had buried ordnance underneath of it, and some of it was live ordnance from back in World War II, and that was up in Cecil County. So I think they called it the Elkton Fire Pit. Not a property that your bank wants to own if they have to go to foreclosure. So you need to get your head wrapped around those issues. Rich, did you have anything to add to the?
Yeah, Mike, that's a real issue. It comes up a lot. You mentioned gas stations. That's probably where it happens a lot. But we had, and look, you know, your bigger lenders are very risk averse. So if there's an environmental problem, they don't want to be anywhere in the title. You know, for 20 years, somebody comes and says, "Oh, you were in the title," and it's they're the last guys left with deep pockets. We had one that, excuse me. It was a church in Hagerstown that had a pool in the building, and they had basically abandoned the property for about 6 months, and the pool was just toxic. And the bank, there's some of the options that you have. You could put it into a receivership, and if you think it's worth trying to clean up and that kind of stuff. But in that instance, the bank actually donated the building to the city of Hagerstown, and they took it on and cleaned it up. So,
okay, and going on to subpart 5, the appraisals, and I think this will also dovetail into the identify the type of property. You need to look at the appraisal closely. You need to speak with your client about your property and ensure that it does not have any apartments on it, that there's no residential aspect to this property where someone could conceivably consider it to be residential property and therefore subject to the residential property restrictions under the Maryland Code. It seems like a simple thing, but it's happened to me before. I've identified them before I've started the process, and then I've found out when I've showed up at the sale and we finally gotten access to the property. For instance, I was foreclosing on a restaurant in Ocean City, and the second floor had apartments where all the employees were staying. And I know that you could conceivably foreclose on that as a commercial property. Some people probably would have went ahead with their sale. I canceled the sale and then refiled as a residential non-owner occupied property. It's just, those are types of issues that you need to try to determine before you file anything. With respect to the appraisal, Rich had made a point that he added to this outline, which I thought was a good one. With your larger cases that involve a lot of money, you need to assess whether the appraiser is qualified to serve as an expert witness. That can be really important if the borrower eventually files for bankruptcy and you have evaluation issues. And I think if you need to get a different appraisal or an updated appraisal when you're in the foreclosure process and you anticipate that this may be litigated, that it may end up in bankruptcy, it's a good idea for the attorney to order that appraisal. So it can't be it doesn't have to be disclosed. Rich, I don't know if you have any thoughts on that, but that's
it's gosh, I've used tons of appraisers, and you know, and some of them are really good, but you get them into court and they're just not comfortable being in court or testifying, and you know, I've seen them kind of melt down on the stand. So, you know, you want to make sure that they've at least done it, you know, once or twice before, or at least some kind of a public forum, so they're comfortable doing that. You definitely want to make sure that you prep them, because you know, this is not what they do for a living. So you want to make sure you got the right guy. There's no doubt about that. And I think one of the things too, Mike, with it to be aware of with the appraisals is kind of with the title work is that things have slowed some. So with COVID, it seems to be getting back on track pretty good as far as doing your title work and getting it back and doing getting their appraisals. But just plan ahead because there's there are things that could still slow that process down. So you want to make sure you plan ahead.
Yeah, and with respect to new appraisals and appraisers that have testified before, sometimes you're dealing with loans that are not large enough to justify the expense of getting a new appraisal. So you just want to make your client aware that you are not familiar with this appraiser or that you've seen him in court. And if this goes south, he or she may not be the best witness. And just make them aware of that, just so they know going in. Government permits, you need to determine the status of any permits necessary to complete or operate, complete the project or operate the property. And again, I think appraisals can be helpful there. The timing of the foreclosure action, commercial foreclosures, unlike residential, we don't have the 2 45-day waiting periods where we have to wait to file it and then wait to actually conduct it. It's a pretty streamlined process. So subject to any of the legal advertisement requirements for the 3 consecutive weeks prior to the sale, there is no waiting period. The location of the foreclosure sale. This is something where Rich and I probably diverge. I know Rich's practice is to hold it almost exclusively at the courthouse. I prefer, if at all possible, to hold the sales at the property. I like the purchasers to see the property if you can. Now, if you have a debtor that's trying to fight you on this or is going to be combative, that's something that you need to take into account. And we have obviously held sales at courthouses. I have one coming up that's going to be at the courthouse because the debtor is not cooperative. I think there's also an issue with optics that sometimes your client may not think about. Banks don't want to be seen foreclosing on churches, cemeteries, or VFW halls. I've done all 3. I've made them.
Cemeteries?
I'm sorry?
Cemeteries?
Yeah.
There's a whole bunch of things I would just love to say about that, but I'm going to just let you proceed.
Yeah, this is where my Catholic guilt shows up. Just a quick anecdote. This is when I first started. I was with another attorney here. He asked me to come along, I guess because I'm a bigger guy, and he knew this was going to be a problem. But we were foreclosing on a cemetery, and apparently people can prepay for their lots, and there is a trust fund statute in the state of Maryland, so that money is protected. This guy was nowhere to be found, and people thought that they were going to be losing their lots that they had paid for. So there was about 30 people there, very angry. There was a TV camera there with a newspaper or a reporter. And it was horrible optics, and we canceled the sale. I've also had plenty of church foreclosures where I don't think it's a good idea to be standing in front of a church foreclosing on that. And the VFW hall also be held at the courthouse. So those are just things that you want to think about. Rich, did you?
Hey, Mike, going back to the cemetery, you were talking about the optics, and it's difficult enough with having the cemetery and having people whose money are gone and things like that. But didn't the owner of the business show up at the sale as well in his Porsche or Maserati or something?
Unfortunately, the attorney that I was with drove us down in his Porsche, which I thought made the optics even worse. So it was, I forgot to mention that part. It was just horrible decision all around. So you want to think about that. It's a mistake that will never be made again. So the last item on subsection B was ensure that the sale is commercially reasonable. So that goes with the timing. You don't want to hold your sale during holidays. If there's a blizzard that comes through, you're going to have to cancel it. We just had one actually a few weeks ago. I was on vacation right where the hurricane hit, but my partner was the other substitute trustee, and we knew that the storm was fastly moving up the coast. So he had the auctioneer rent a large conference room at the nearby hotel, and we had people at the sale that were directing people to the hotel so we could conduct the sale. But I thought that was reasonable, but you want to make sure that you're not holding your sale on days that just are going to be inconvenient or maybe considered not commercially reasonable. We try to avoid the extreme winter months, mid-December through probably mid to late February. I just don't think that's a good season to sell property.
You think the Friday after Thanksgiving is probably a bad day?
Yes.
I have actually had clients that have asked me to do that on those days. So
that doesn't work. And obviously with the pandemic, you have to be aware that this may happen. The state may be shut down again. If that happens, and if you have a sale scheduled, you're going to have to cancel it. I don't think that would be commercially reasonable if they start limiting travel again.
yeah, and that, Mike, that came up early on in March, in early April, that the moratorium started coming out, and there was the state of emergency, and people were of the mind that we can still go forward with the commercial foreclosures. It's not really affecting any of that. But the question there is that with the court shut down and everything else, even though it's a non-judicial sale most of the time in Maryland, it probably was not commercial. It wouldn't be commercially reasonable, at least early on. Yep. In the pandemic.
And we've already talked about identifying the type of property. Again, you're going to take a look at your appraisal, and if at all possible, have someone inspect the property if there's any question that there has any residential aspect to it. So Rich, you want to cover the filing?
Yep. So after the due diligence, the things that Mike and I have talked about up till now, you actually come to filing the foreclosure action itself. One of the things that's interesting, and gosh, I've probably only seen it once in 20 years of practice, but is that you don't have to do a non-judicial sale in Maryland. There's, gosh, I don't even remember why we did it. I know there were specific reasons that it was done that way when I ran into that, guys, probably 15 years ago, but that is available. Just to know off the top of your head, I don't know how much you know about it, Mike, but I just know that it takes a lot longer than foreclosing under a deed of trust.
I've never done it before, but I almost wish that instead of the 500 notices that we have to send out for residential foreclosures, they would just make it a judicial process where you have to serve them and just get it over with. But that's water.
Well, I mean, you mentioned that, with all the stuff that you have to do, not just with residential is definitely much more burdensome, but even on commercial stuff, when you're filing the order to docket, especially now where there's e-filing in most of the counties, it can be a little tricky. I know that I was telling everybody earlier that I think the first couple of times that I tried to do it, I ended up doing Control-Alt-Delete and rebooting because I had forgot something or I couldn't figure out what was going on. But if you have 6, 7, 8, 9, 10 exhibits, it's you just want to be careful, make sure that you get everything before the court. The nice thing about that too is that when you file stuff, e-filing, if you have like 30 exhibits, you're going to get about 100 emails saying that it had been filed. So that's just another thing to be aware of too. And it's you have to see, is it did it take the documents? Is it sending you a receipt for the payment? That kind of stuff. So it may seem fairly straightforward, but it can be tricky. It can definitely be tricky. So
and one thing on Rich and maybe you haven't gotten to it yet, but the actual documents that you're filing, the statement of debt, you're going to want to make sure that you include all fees up to that point. If you have a IDOT securing a guarantee that may secure more than one loan, that could, even as the second loan is secured by a second lien on the property, if that loan could conceivably be considered secured by the first, I would include it on that statement of debt. And that would avoid some steps that you have to take at the audit process.
So that's some of the stuff about filing the order to docket if you're doing a non-judicial. Again, judicial is available. I couldn't even tell you how to do that. I know that it takes a long time, it's not as efficient. But I know that also that there may be reasons that you run into that it just makes more sense to do it that way. So one of the things about filing the order to docket too, Mike made the point about, if you have multiple loans secured by the deed of trust, try to include them all in there. It's just kind of streamlines the process. Also, one of the things that I always catch it, I've never missed it, but I always kind of catch it at the end is don't forget to do the non-military affidavit as well. It seems like a no-brainer, but it just seems like you go through it, you got your client doing all these affidavits and statements of debt and everything else, and then you forget to file the non-military affidavit.
And Rich, do you attach your non-military search as an exhibit to your affidavit?
I do. I went online and years ago and got an account. It's easy to do. Anybody can do it. I think you just certify that you're a lawyer or work for a law firm, and that's why you're doing it. But the best way to do is to go on the website, get an account, and then you can search by the Social Security number. You would think that your clients, especially banks, financial institutions, would have that information. There are other ways to do it. I think you can do it by name and date of birth as well, although I don't think that you may have some holes in that one if you don't actually use the Social Security number. Yeah. But it's just, it's an easy way to do it. It's, you just go on there, it takes 2 seconds, and then you print out the receipt that that person with that name, did not show up as being in military service.
And your client should have the socials for all individuals involved in their loan.
And remember too, that it only applies to individuals, although I have had deficient pleadings where an LLC was not contained in our non-military affidavit, and the clerk wanted to know why we didn't do that. We just amended it, and now we just add the LLCs to say that they're not a natural person. Just
that's how I handle it. I file one even if it's an entity.
Yeah.
Just to avoid that issue.
Again, I love those guys. They just they keep things moving, but sometimes they try to play lawyer. So, Mike, I think you're next about the sale itself.
Okay. First step, and this is going to happen when you're starting your due diligence, is to get an auction proposal from an auctioneer. Not all auctioneers are built the same. Some are better at certain types of properties than others. If anyone is just starting this process or starting this practice and wants some recommendations, I'd be happy to provide that to you if you want to send me an email or give me a call. But I certainly have preferences depending upon the type of property that we are foreclosing on. You then have to draft and publish your legal advertisement, which is going to run for 3 consecutive weeks leading up to the foreclosure sale in a newspaper of general circulation. I know that this issue has been raised in the past, and it wasn't a successful defense to a foreclosure sale. There was an unreported decision in the Court of Special Appeals, Waith et al. Versus Khan. It was in July 7, 2016, where the debtors argued that the Jeffersonian was not a newspaper of general circulation. And if you read the opinion, it appears that the court wasn't necessarily ruling out that argument. They were just saying that based on the evidence provided that it was invalid, or that they overruled the objection. I think that issue is valid. I don't want to give debtors counsels on the call more ammunition than they already have. So I tend to use the Baltimore Sun or larger papers on my commercial foreclosures. I know with residential foreclosures, there's a cost aspect to this, and some of these smaller papers, even in the outlying counties, can be pretty expensive. But so
not cheap. It is not cheap.
So to the extent you can use the Washington Post or the Baltimore Sun, I would say go ahead and do that. And I think this is even more applicable now. What these papers are dying. If you look at the Jeffersonian, I tried to find their circulation online. I think I saw that it was like 2,500 per day. I don't know how many people live in Baltimore County, but if you do the math, it's going to be way under 1% that it's reaching. I don't see how anyone could possibly argue that that's a newspaper of general circulation. I read the opinion. I just don't agree with it.
Yeah, and Mike, that's interesting that you said that, because we've stopped using that paper for that exact reason.
Yeah.
I think what we do now in Baltimore County is we use the Daily Record because it has a pretty good circulation in the city and the county.
Yep.
So we've been using that. On the Eastern Shore, it's a little bit of a challenge because you don't have a lot of options. And look, I would probably use the Sun, but I'm not sure if the Sun would be, general circulation in, Wycomico or another county. And most of those counties, there's only one paper.
That's all that we're left with at this point.
Yep. Maybe they'll all go online at some point. Who knows?
Yeah, we're getting there. The legal advertisement itself, everyone has their own form. There's a few things I wanted to touch on. Obviously, you're going to have the date, location, time. With respect to the location, if this is not if it doesn't have a hard address and you just have a legal meets and bounds description for your property, if it's raw land, it would be wise to include directions to where you're actually holding the sale. Sometimes that's not evidently clear. The terms of sale, whether you are apportioning taxes and closing costs to the date of sale, we don't do it that way. We make the purchaser pay for everything, so the trustees are coming to the table not having to pay anything. You got to have the as is, where is language. You need to include the full legal description of the property as it appears in your deed of trust that you are foreclosing upon, and make sure that matches up with the title commitment as well. If there are any senior liens, and this is something I didn't touch on before, but if you're going to foreclose from a junior lien position, you're going to have to make sure that you file your order to docket before the senior lien order does, because you can only have one foreclosure at a time. But if you do have a senior lien, make sure you include in your legal ad that it's being sold subject to that senior lien. And with respect to some of these commercial properties, if you have good leases that you don't want to wipe out, you can keep those leases and you can sell it subject to those leases. So I like to include that in my legal ad if I'm selling subject to the leases that are in place. I include a language that says, at settlement, the purchaser shall provide all additional information and documentation reasonably requested by the trustees and or the note holder in order to comply with all applicable anti-money laundering, anti-terrorism, and other applicable laws or regulations. Some of the larger banks are starting to ask these purchasers for that information, and purchasers understandably are balking. They don't want to provide more information that is necessary for an as-is, where-is sale. But if you have it in your legal ad, there's really no wiggle room there. We also include the exculpatory language that all information contained herein is for informational purposes, nothing can be relied on, and so forth, because that just goes with the as-is, where-is sale. You want to give them as much information as is required under the law, but not so much that they're starting to hold it against you down the road. I had included a couple cases there in the outline about including talking about legal fees. You can't do that. You can't require a purchaser to pay the trustees legal fees unless there's a default. You want to update your title report again within 30 days of the sale. And then we get to the notices of sale itself. I'm not going to go line by line here. Everyone that has done this. The way I work, and I'm assuming the way everyone else works, is when you see your lien report, you start to calendar all of your deadlines. You work backwards from the sale date. The one that's a little tricky could be the IRS notice, because it's 25 days out, but not before 30 days, I believe. So you have a small window to send that. So I try to make sure that if there's any IRS liens, I get a copy of that. Sometimes they're a little difficult to get. They do expire after 10 years. So if you see that on your title report and they're over 10 years old, just tell the title company to remove that as an exception. But then we send our 25-day IRS letter, your 15-day letter to the county or the municipal corporation. So for instance, the town of Ocean City, you have to send them a separate notice. So just be aware of that. If there's any municipality that requires, that has a separate tax bill, you're gonna have to send them notice as well. So those letters are obviously sent at least 15 days prior and not more than 30 days prior to the sale. Then we get to the 2 10-day letters. The 10-day letter goes to all occupants. The grantors under the deed of trust, all other obligors, and all junior lien holders, or any holder of any subordinate interest in the property. Have homeowners association, condominium association. I try to include them. I over notice my 10-day notice. One thing that I also do, I don't think it's sufficient to take a look at a lien that's been filed in land records 10 years ago and just use the notices, the notice addresses that are contained within that lien instrument. I think you need to take an extra step. You need to look online to confirm that if there's trustees that were lawyers at the firm representing that lender, you need to look them up. And if they're not with the same firm, you need to send it to their old address and their new address. You need to confirm. A lot of these banks, as everyone knows, they merge, they are sold. I try to do a little bit of due diligence in that regard. I think it makes a lot more sense to spend a few bucks to send an extra certified mailing than it does to litigate after the fact when someone claims that they haven't received notice of the sale. So I think you really need to spend a little bit of time here ensuring that everyone possible gets notice of this sale. Most people will ignore it anyway, but just make sure that you have notice of that sale. The other 10-day notice is what we call the 10-day all occupant notice. And I'm sure most folks have realized this. Maryland Rule 14210B references Maryland Code Real Property 7-105.9C. It's actually 7-105.11C. Although 7-105.11C addresses notices to occupants of residential property, the Maryland Rule 14210B has no such restriction. So my firm, and I know Rich's firm as well, out of an abundance of caution, sends that all occupant notice that is outlined in Maryland Code Real Property 7-105.11C, even though it's not a residential property. I still think it makes sense to do that.
More is always better. Yes,
always. And you got to make sure that your envelopes have that magic language in 12-point font. Then you file an affidavit of mailing. Sometimes I'll include that with my report of sale. I'll include my report of sale, purchaser affidavit, auctioneer affidavit, contract of sale, affidavit of mailing. I'll do that all together. You have to file your foreclosure bond prior to your sale. I like to get that done at least a week or so before the sale itself. I mean, it's a small expense, usually only around 150 bucks, at least for the initial $25,000 bond. But again, what just happened to me, I've got a sale coming up and the court was kicking my bond because I didn't comply with that declaration of moratorium requirement, which it doesn't apply. So it's just something that you want to make sure is on the docket, has been accepted by the clerk, especially if it's e-filed, has been accepted, and you get that notice from the court that it's been accepted. With the bond, if the property is sold to a third party, you have to increase that bond to the amount of the purchase price, unless it's a bank buy-in. I often will file after the sale, along with my report of sale, an affidavit that no supplemental bond is required if the bank does buy it in. Before you attend the sale, you're going to want to run some bankruptcy searches. I run them at least a couple days before the sale. I run them the morning of the sale, and I'll actually have the website pulled up on my phone right before right during the reading of the legal ad by the auctioneer. If you think that this is a probable, or if you've been advised. If it's an individual that's not represented by counsel, you may also want to call the court. Sometimes they'll send in their petition. They'll mail it in or they'll drop it off. They can't e-file. So I think that the clerk will actually keep a list of, or at least they'll have the stack of filings right there so you can confirm that. You need to have your bid sheet prepared and verified by the bank officer attending the sale. You need to make sure the bank has their entity established, especially if there's environmental concerns. You're not going to take this in the name of M&T Bank. You need to have an entity set up. Check the docket, make sure all pleadings that you filed are reflected on the docket, so there's nothing missing prior to the actual sale date. Make sure that the auctioneer, if most auctioneers will bring their own contract to sale, owners or a purchaser affidavit, auctioneer affidavit, I still like to look at them, touch them up if you need to, and make sure you have multiple copies of that, because who knows if you need multiple copies or if there's mistakes that are going to be made. And then the conduct of the sale itself.
Hey, Mike, real quick, on the issue with the auctioneer and the contracts and the documents, I do the same thing. They usually bring their own. I take a look at them. Something that I've actually seen, because I have a sale tomorrow, is that some of the auctioneers are doing these COVID documents that kind of says if there's a third-party buyer, that they realize that COVID may slow some things, if there's, problems, slowness in the court, recording, things like that. And that if that becomes an issue, then we can extend closing by 60 days. I hadn't seen that until today when I was just looking at it, but it sure makes sense to do that. And so that was just an interesting thing that's come out of the recent news with the pandemic and everything.
And then the conduct of the sale itself. We always have the auctioneer read the ad prior to conducting the auction. You want to make sure that the auctioneer has some type of process where they are actually registering bidders, and you don't just have random people throwing out numbers. On larger foreclosure sales, since we are talking about commercial foreclosures, I always like to have a property information package or informational packet prepared that the auctioneer can distribute to potential purchasers at the sale. That would include a copy of the legal ad. It includes pictures, maybe from your appraisal or from the auctioneer, online listings, property description, highlights, zoning, rent roll, tax map, a P&I statement if you have a cooperative borrower, floor plan, recorded condo docs, plats. But you also want to include at the bottom of this what we call a PIP, the exculpatory language. You're just providing this for informational purposes. I do not share title work with purchasers, even though they ask for it. They have to do their own due diligence. Sometimes they will ask if there's any liens in front of you. I don't have any, Rich may disagree, I don't have any problem informing him that my title report reflects that there are no senior liens in front of our lien.
Yeah, no, I'll say that to them, that to my knowledge, that this is what the record shows. I definitely don't like to give out appraisals either, and a lot of my bank clients just they don't allow us to do that anyhow. Some smaller banks don't care as much, and so if you do share the appraisal, you may want to get some kind of a waiver that it's we're not standing behind that. That's a third party. There's you rely on it at your own risk.
Or I mean, sometimes if you don't have a PIP, I'll redact the appraisal and just give them. That just gives them the meat of the appraisal without any value information. Sometimes they just want to see some of that stuff. I announce the tax balances if I receive a letter back from the county or a municipality regarding those items. I'd like to announce that after the auctioneer reads the legal ad, but prior to the sale itself. I think it's a good idea to clarify if you have a property that has a lot of equipment inside that you are just selling the real property. Now, most cases, your client is going to have a lien on the personal property and equipment. I have done it plenty of times before where you've scheduled your UCC sale at the same time that you schedule your foreclosure sale. But again, that's two different sales. It's two different sellers. The UCC sale, while it can be conducted by the auctioneer, is really being sold by the bank as secured creditor. The foreclosure sale is by the substitute trustee under the deed of trust. So you need to meet that clarification. I have included a reference to the UCC sale in my legal ad in a separate section, indicating that the bank is in fact selling, whatever items that you are selling. And then you'll have to obviously issue your UCC notice at least 10 days out. I don't allow and there's a reason I'm mentioning this. I don't allow the auctioneer to hold the deposit from the winning bidder. I'm sure most people don't. I had an auctioneer who will go unnamed who tried to tell me that he was going to take that with him. That I don't use him anymore. That doesn't happen. That doesn't work. You have to hold that money in your IOLTA account, and then it can be dispersed at closing, or it can go towards the purchase price at closing. I'm sorry, not dispersed. We have to wait until the audit. You have the purchaser execute the contract of sale and purchaser affidavit while you're standing there. Get them on the hook, collect their deposit. I also instruct the purchaser that they have an insurable interest in the property once the hammer falls. That is the law. I have been told, and I have another sale right now where a purchaser is complaining about this, that they are having trouble getting the property insured on their policy. I don't know, Rich, if you've run into that as well, and I know that once you get to foreclosure, most banks are probably force placing insurance anyway. So it's not like you're going to lose the property, but at the end of the day, under the terms of my legal ad, if the property were to burn down the day after the sale, that's on the purchaser. So we tell them to get it insured.
We always mention that too, because again, it's just coming back to, better safe than sorry.
Yep. After the sale, I try not to make any promises, but some of these purchasers, this is the first time that they've gone through this process, so I will provide for them a quick outline of how this process works, what to expect. It's a good idea, I think, to do that so they are not getting upset with you a month or two down the road. Why isn't this ratified yet? I mean, if you're in PG County, forget about it. So it's a good idea to just give them an idea and just tell them, this is out of my hands at this point. Sometimes we have in our legal ad provision where they'll have to increase the deposit to a certain percentage of the purchase price. And that interest is going to be running up through the date of closing. I'll make sure that they're aware of those provisions so they're not upset about that. When we get to
and Mike, one of the things that happens a lot of the times, I'm sure that you run into it. We talk a little bit about that in the post-sale stuff, but it's tough to predict from court to court or really from file to file when the ratification order will be entered. So it's hard to give a timeline to a buyer. I know, gosh, probably more times than not, you got to call the clerk and say, hey, can you put the file in front of the judge? It's been 35 days or 40 days or whatever. Some courts are better than others. I know I've done some on the Eastern Shore, and they do it on the 31st day. But also when you file foreclosures, the clerk will call you and say, hey, if you need anything, we're here, and that kind of stuff. And I think that maybe just they're a little bit slower in some of the other courts, so it gets done faster. But just something to be aware of.
I like it when you show up and the sheriff says, you're here. It's like they're expecting you to show up. They don't have a lot going on in some of those counties.
Exactly. So it's tough to get the timeline. It's tough to tell them. I mean, it could be right on that 31st day, but it could be 60 days, even 90 days. So
I think Harford County, if I'm not mistaken, requires you to file a line requesting that the file be sent to the presiding judge for ratification. It's one of those counties up there. So
that's a good point, though. You want to be aware that each court is different.
Yeah.
And they do things differently. I know on the Eastern Shore, there's 3 or 4 counties that as soon as you file it, they set a status for like a year out, just so that this case doesn't get filed and then it just sits there.
Yeah.
So I got one the other day and I was looking at it and it was saying October 15th and I'm going, that's really short. Then I realized it was 2021.
At last point here, a lot of times you'll have a purchaser for commercial property sign in his individual name under the contract of sale, but he'll want to set up an entity after the fact and you'll have to substitute that purchaser. And I always go ahead and just prepare that. It's a rather formulaic document. I don't know if you do the same thing, Rich, but it's just easiest if we just go ahead and do that for the purchaser. Okay. we still on my section? Oh, no, I think we've now moved on to the report of sale, or is that still me?
Yeah, the post sale, I guess.
Okay.
Section 5 on page 10. Sean, do we want to kind of start to wrap it up here and start to take a few questions as well? I know we're getting
Yeah,
close.
that's fine. We've got about 4 or 5 questions that we need to get to. So if you guys want to wrap it up and touch on anything that's any salient points.
Yeah, this outline is very comprehensive. Mike and I did a lot of work on it, and Mike did a lot of work on it. And did I mention Mike did a lot of work on this? It's really comprehensive. It's great. In fact, I have my own checklist that I use, but I'm going to use this to supplement it because it really kind of hits all the points. We talked a little bit about some of the issues with the report of sale. You might have to nudge the clerk. Don't forget you got to do another advertisement as well. Those are generally a little bit smaller, so they don't cost as much as the original ones. And again, talking about the Eastern Shore, a lot of these properties that I've foreclosed on don't have addresses. And so it's the legal description, which can be like 3 or 4 pages. And that's where it really starts to cost money. But the second ad is definitely usually cheaper. It doesn't require as much information.
And I wanted to touch on just 2 quick things before we take questions, if you don't mind.
No, fire away.
One of the more difficult aspects, and it should be easy when you're wrapping it up, is the auditor's report. And there were some comments that I had written in the margin here that aren't on the outline. Commercial foreclosures are often the last step in a long, drawn-out battle with the debtor that may involve a long bankruptcy case, an expensive bankruptcy case. And as everyone probably knows on here, court auditors do not allow a lot of attorney's fees. They don't allow auctioneers' commissions that should be paid. So if it makes sense, if there's equity in the property, you may have to file a motion with the court to allow your fees, which could span literally, a year and a half or longer, depending on the case. And then also allow your auctioneer's commission. You're going to end up paying your auctioneer whatever you agreed to pay them. But it's nice to get that out of whatever equities in the property.
Yeah, I just did one, Mike, and I think the auctioneers, I don't remember what the county was. I think it might be Dorchester, but the auctioneer's fee is limited to $200.
That's a joke. I don't know when that was created. But
I think it's just local custom. I think they just, if they've done it some way or some judge issues an order, I think in the same county, I think the attorney's fees are $3,500. So it's again, going back to the individual courts, they have different customs and they have nothing really written in law. It's just, I don't know if the auditors came up with it, the court came up with it, but it can be a problem at times, getting really all of the expenses back.
Yeah, I mean, working on these commercial cases, first-year associates bill more than that for an hour. It's just not realistic. Sometimes you can barter, or I've tried to barter with the auditor on your fees versus the trustee commission. I don't collect the trustee's commission. I often tell them that I'll waive my trustee's commission, which could sometimes be 5% of the purchase price if they just allow my fees. And sometimes that works, sometimes it doesn't. It's an idea. I don't collect that. I don't know if you do, but
No. I mean, maybe once, years and years ago.
Yeah. If the bank has junior liens, I try to put that on my audits. We just pay that without having to get a separate order from the court and file a motion for payment of surplus proceeds. And then finally, you can't disperse funds until the court ratifies the audit. At least that's my practice. I know some smaller clients that aren't familiar with the process may be upset at the delay. Certainly I had one with COVID that was taking months and we were sitting on a lot of money. But we can't do anything until we have a court order. And that needs to be made clear to your client. That's all I've got.
Yeah, I think the only other thing that I would add to that, Mike, is that what do you do when the sale's all done and the people haven't left? It's especially with if it's residential / commercial, 1 to 4 multifamily type stuff. And there is a provision that I think it's just a writ of possession that you can file in the foreclosure action itself. And I know in some cases the courts just enter them almost right away without even giving anybody time to respond. So
Yeah, I don't know. I mean, do you handle that? Because if I'm selling this to a third party, it's not my problem anymore.
you know what? I think the couple of times that I've done it, I think we've used the sheriff.
Oh, okay.
So once we got the writ of possession. So
Yeah, and I'm sure, as everyone knows, they just enacted the Maryland Receivership statute. I helped out on that a little bit. I was more of a bystander, just kind of watching how the sausage was made. But that is also an option if you believe that your debtor is going to be difficult, not leave the property. It may make sense at the inception of the foreclosure case to also file a motion for appointment of a receiver, so you can get that debtor out of there. And I think now there's a lot of questions here. Do you see the chat at the bottom?
I have those listed in order here. Thank you, gentlemen. You did an outstanding job. I realize that this is a often thankless and voluntary task, and you covered a lot of material. I suggest to the group, if anyone has any specific questions, that it would be okay to reach out to either Mike or Rich directly. First question,
Sean, I would just say that this isn't legal advice, and if you need actual legal advice, then you should contact an attorney.
Nice disclaimer. Yeah, thanks, Rich. So we're just going to cover a couple of questions here that came across. One of them says that my reading of the CARES Act moratorium indicates that it applies only to servicers taking certain actions. Would it apply to motions for possession by the buyer following the sale ratification?
I know I saw that early on. I think that was Kendall that had sent that out there. And Mike, I'd like to hear your position, but I would think that once the sale is done, there's case law that indicates that title is pretty much transferred at that time. The only thing that's remaining are that you could file exceptions to the sale. But I think the term that Judge Keir used in the bankruptcy case was when the gavel falls, then they're basically the property owners are no longer entitled. And
I think he said bare legal title. I think that, or it's bare legal title after the
right, always subject only to exceptions in the sale process. So I would think at that point that if the buyer and Kendall, I'm not sure if you had closed and the auditors doing the report and everything, but if you are the buyer and you're at that point, I think I don't think it would be covered, to be honest with you, because I think the sale is over. As long as the sale itself was good, I think you should be okay.
Well, and again, this happened to me where I had an audit, and they were trying to apply the moratorium to it. I think no matter how we interpret it, you're just going to have to deal with that issue. And if it makes sense to spend a half hour on an affidavit as to why this does not apply, I don't know if you would file that if the court were to raise that issue. But
yeah, Mike, here's just to say that in the declaration, we're filing them in all the cases now.
Yeah.
Just so that it's clear that exactly what my people do and why we don't think the moratorium applies.
Okay.
So the next question is a title-related question, and I know from experience that sometimes you can't often rely on a title policy because obviously not all title companies are created equal. And if a claim comes up, you certainly don't want to be stuck in the middle of litigation. But the question is, for your title search, do you do a full search or only a bring to date from the policy?
Full.
I've sent it to Sean to do the title work and commitment.
That's a great answer. Next question says that if the property is zoned residential, but it's an investment property and not occupied, is it still subject to the moratorium because it's residential? I know you discussed that earlier as well.
It will depend on the lender and whether or not there's it's federally backed. That process, if it's non-owner occupied, is a little bit faster. But if it's Sean, it'll depend on whether it's leased or not as well. If it's vacant or abandoned, none of the moratoriums apply. But you have to go and look at the mortgage to see whether it's FHA backed, Fannie Mae, something like that, because it's residential property. There's no exception that I see in the moratoriums for non-owner occupied. Mike, I don't know if you've seen anything different, but
I haven't.
Another question is, although this is a commercial seminar, could you address the impact of the Maryland Current Emergency Order shutting down the Notice of Intent registry at the Commissioner of Financial Regulation?
Okay, I'm going to say this again, that this is, if you need real legal advice, you should contact a lawyer. But what we have done, to be honest with you, is that if you have already done that and are in the foreclosure process, that unless another moratorium applies, that you're not stayed. But if you actually have not sent the NOI out, I think you're stuck. I don't think you can start it. And I think the way that the state of emergency order is worded, I think you're okay if you've already sent out the NOI. I think you could even make that argument if you haven't filed the order to docket. But the NOI went out before all of this started. And that's just, again, remember the state. So you still have to go and look at whether there's a federal moratorium as well.
Okay, so apparently in Montgomery County, there was a commercial sale and Judge Greenberg refused to ratify it based on Rule 14-2071. Court screening review of the advertisement due to purchaser having to pay certain expenses. They say this happens frequently in Montgomery County. Do you know if there's any other jurisdictions where that has occurred, or are you familiar with that at all?
I think I've heard of that maybe once, but I haven't had, I know another attorney had that issue pop up, and I think for some reason Montgomery County is kind of a stickler for that. But I haven't had any personal experience with it, and I've handled a lot of foreclosures where everything is pushed to the purchaser. We don't have any special fees in our sales. Everything's, it is what it is. You have your taxes, you have the purchase price. But so I guess my question would be, what fees are we talking about?
Okay. So I guess the final question we have here is regarding disbursements. It says you have to wait the 10 days provided for in the rules for judgments. I don't know, it says Howard County required an affidavit to get the audit reviewed.
Say that again, Sean?
So it's on the chat box. It says for disbursements, do you think you have to wait the 10 days provided for in the rules for quote unquote judgments?
No.
Howard County required an affidavit to get the audit reviewed. It says if the borrower no longer has equity redemption of the gavel if it's ratified. That makes sense.
Just to answer the first question, I don't wait. As soon as I have the order in hand, I don't wait. I don't know if you do, Rich, but I do not wait.
No.
The other questions, requiring an affidavit to get the audit reviewed, I'm not sure I'm following. I don't know what that means.
Oh, I think, yeah. And again, this goes back to every court is different. It's just the way that it is. It's how they treat, especially the post-sale stuff, how they treat stuff. So I think you kind of got to know your judges, and you got to know the clerks too, and the auditor, and what they, what they let you have, what they don't let you have. Not sure about that, about the affidavit to get the audit reviewed, but
once the auditor files the audit, the 10 days starts. That's it, and then you just follow up with the clerk to get them to ratify the audit. I've never had anyone ever tell me that you need an affidavit to be filed in order to have that reviewed by a judge.
All right. Well, I think that's about it for the questions, gentlemen. I really appreciate it again. Thank you so much for your efforts, and good luck with everything. And hopefully we'll see everyone in October for the next installment of the commercial discussion group.
Thank you, guys.
Thanks, Sean. Thanks, Mike. Thanks, Bill. Angela.
Take care.
To be filed in order to have that reviewed by a judge.
All right. Well, I think that's about it for the questions, gentlemen. I really appreciate it again. Thank you so much for your efforts, and good luck with everything. And hopefully we'll see everyone in October for the next installment of the commercial discussion group.
Thank you, guys.
Thanks, Sean. Thanks, Mike. Thanks, Bill. Angela.
Take care.
To be filed in order to have that reviewed by a judge.
All right. Well, I think that's about it for the questions.